On Canberra Live with Marcus Paul, legal advice from Blumers Lawyers.
Bill Redpath joins me from Blumers this afternoon. G'day, Bill.
Good afternoon.
Nice to talk to you again. Now, I understand that a Belconnen man accused of robbing a Southside servo with a makeshift spear has been banned from leaving his house at night. Now, is this a common bail condition? And I'm glad that he has been, kept away from service stations, but is this something that happens all the time?
No, it's pretty unusual to have basically a curfew type condition. Conditions for bail are a regular feature of bail. The presiding magistrate is able to exercise discretion.
I would have thought that a man accused of robbing a service station with a spear should actually be in remand. That's just me personally, but anyway.
Well, I gather from that bail wasn't opposed, which I found interesting. I suspect that there are some broader issues on this one, and that there may be some mental health issues or something else to it. But yes, bail wasn't opposed, but the magistrate thought it was that some conditions ought to be set, and set those. Okay,
where are we up to with the Eastman inquiry? Now, let's just go through it. Convicted murderer David Eastman has threatened to have the ACT Director of Public Prosecutions declared a vexatious litigant. What does that mean?
Okay, a vexatious litigant is someone who brings litigation or applications to the court without merit, and if they do it a number of times, court can declare someone a vexatious litigant, and then they have to get leave in order to actually bring action and explain why they should. Now, it's interesting for it to be said, but it's very unlikely that the Director of Public Prosecutions Office is going to be declared a vexatious litigant.
No, there'd be a bit of a problem there.
That's right. I mean, but they do bring lots of cases, I guess, is the answer. But
that's their job.
That's their job.
Yeah. So the matter will reappear in court later this week.
That's right. So what's happened is there are provisions in the Crimes Act for an inquiry to take place or to be ordered if there's uncertainty around a conviction. That's happened, and Acting Justice Martin has heard evidence, and he's recommended in his inquiry report that the conviction be quashed.
Which is quite sensational. I mean, this thing made national news. It was the front page of all the newspapers. It's such a big thing to happen. Because, given that it was the assistant AFP commissioner who was at the time murdered.
Well, I guess so, though I guess a lot of us who'd been watching this case were not at all surprised
from a legal point of view
that there was going to be some doubts about the conviction.
And why is that?
Well, I think that the critical problem was putting the gun in question in Mr. Eastman's hands, and once that forensic evidence in relation to the gunshot residue in the boot was kind of seriously questioned, which it's unfortunately should have happened at the trial, there was always going to be a bit of a problem saying, well, yes, this guy had some motivation to do it, although Mr. Eastman had a run-in with an awful lot of people and they weren't dead, but nevertheless,
I spoke to Gary Humphries last week, and he even had to have some police protection. He was so worried. Well, the police were concerned about him. What I find fascinating is that in handing down this decision, the magistrate at the time, or the justice, said that he still believes that the crime was committed, and perhaps Mr. Eastman had something to do with it, but he has that nagging doubt.
Well, we do have a system where you just have to have a reasonable doubt. I find that aspect of the inquiry and that finding a little surprising in some ways, because he really didn't need to form a view about that. He only needed to form a view that he had reasonable doubt that there were about the conviction.
Yeah, but he put his own personal opinion in.
Really. Yeah, and I'm not really sure where that takes the matter particularly, or what motivated him to do so. But anyway, the inquiry report goes to the full court, and they've got a range of options from maintaining the conviction, sending it back for resentencing, quashing the conviction,
What do you think will happen?
With the trial. The recommendation is the conviction be quashed. I don't think after these years it's realistic to have a retrial. So that I think the conviction they will simply quash the conviction.
And do you think there will be compensation?
Well, I think then there will be an issue about compensation, and that'll be that will happen at some point.
I doubt very much whether Mr. Eastman could probably live in the ACT again, so he'd probably relocate with a wad of money, courtesy of the government, and off he goes. Anyway, we're
I wouldn't underestimate his capacity to think that he could live in the ACT.
Oh, really? Okay.
Anyway. We shall see. He's undoubtedly an enigma.
All right, so we're going to take a little break. When we come back, we're talking with Bill Redpath from Blumers Lawyers. We'll have a little chat about an aggravated robbery where a man rode a push bike to a planned armed robbery at the Canberra Woolworths. If you're going to go and hold a robbery, you'd probably get a quicker getaway vehicle, wouldn't you? Anyway, we'll have some details about that. And also, a Canberra Construction Company Director has become the first senior company manager to be charged over the death of an employee in a workplace incident in Australia. So we'll look at those two issues in just a couple of minutes with Bill Redpath from Blumers Lawyers. You're on Canberra Live with Markus Paul this afternoon.
On Canberra Live with Markus Paul, legal advice from Blumers Lawyers.
14 minutes away from 4 this afternoon on Canberra Live. Now we're expecting partly cloudy conditions tomorrow, top of 14 degrees, before we get down to 2 overnight. Now showers and rain expected for Friday and Saturday. We're talking the law. Bill Redpath is with me from Blumers Lawyers. Now, a man who rode a push bike to a planned armed hold-up at the Canberra Woolworths, still can't get over that. He rode a push bike, ladies and gentlemen. He might have been a few sandwiches short of a picnic basket. Anyway, he's lost his bid to overturn his conviction. He was found guilty in March last year. What was he charged with again?
Okay, what he appears to have been charged with is conspiracy, so a plan to commit what's known as an aggravated robbery. Now, there are a whole series of property offences. I guess the lowest one is theft, where you simply take something and keep it, shoplift, that sort of thing.
Yep.
Okay. The next one up is a robbery, where you take something and say, give me this or I'll get you. You threaten violence with that, all right?
Yep.
An aggravated robbery is the next step up, where you have a weapon, or
it could be a knife, it could be a firearm.
Can I say a weapon, an offensive weapon is anything that is intended to be used as a weapon, really, by the definition.
Injury.
So it's very broad. And or that you do it in the company of another. The appellant was able to persuade the court that they couldn't be satisfied that he had an intention to bring a weapon, but they said that didn't matter because the other element of an aggravated robbery, namely that he was doing it in the company of another person, was satisfied, so that it was an aggravated robbery.
So did he try and palm it off onto the co-accused?
Well, basically he said that, all right, we did plan this robbery, but we never really planned that we'd bring a weapon. So that therefore it wasn't aggravated. It would just be a robbery, and that would... And there's different penalties you get. I mean, the maximum penalty for robbery is 14 years. For an aggravated robbery, it's 25 years. So it makes a difference in terms of sentence. There's no way you can sit there
and tell me someone who's done an aggravated robbery in this country, in this jurisdiction, anywhere, has done 25 years.
No, they don't usually, even if they turn up with a shotgun. But anyway, that's right. So...
that's the maximum, of course.
But I guess I give you the maximum just so you can see that they're seen in a different way.
Absolutely,
and that's reflected in the kind of sentence that they.
So he's gone.
He's failed again in his appeal against conviction.
Yep.
But he still have his appeal against the sentence for 6 years or whatever.
Okay, so he's got to go back again.
Yes, so the court will make a decision about that.
Okay, in the meantime, is he on bail or is he...
No, he'd be in custody, remanded. Okay.
He's in the Hume Hilton.
Yes.
Okay, good to see. All right, now, a Canberra Construction Company Director has become the first senior manager to be charged over the death. Now, this is history-making. The new industrial magistrate is operating now in the ACT, as we know. It was introduced by Simon Corbell earlier this year, I believe. So we're going to have a chat about that next with Bill Redpath from Blumers Lawyers here on Canberra Live.
On Canberra Live with Markus Paul, legal advice from Blumers Lawyers.
8 minutes to 4, Bill Redpath joins me from Blumers. We have our legal segment this time every week after 3:30, between 3:30 and 4. Now, a Canberra Construction Company Director. This is history-making, Bill. Under the new industrial magistrate here in the ACT, there's been a charge over the death of an employee in a workplace incident. First time in the country, I understand.
Well, there are only some jurisdictions that have a charge of industrial manslaughter. Mostly what that is criminal proceedings for a death in a workplace. In addition to, say, civil liabilities you'd have under the Workers' Compensation Act for compensation, things like that, and perhaps some civil penalties for occupational health breaches. There are also, if it's sufficiently serious, a criminal charge of industrial manslaughter, that somebody is killed as a result of your negligence or recklessness. Normally action is taken against the company, because it's much easier to say, well, it was the company through its agents and servants that actually caused this death. In this case, because the company is going into liquidation, there's some issue about whether there isn't much point in bringing the action and what would happen, so that there is provision under Section 49D of the Crimes Act to actually charge a senior officer. The challenge will be really in terms of the conviction, you'd have to show that it was the senior officer's conduct that directly caused the death, and that conduct was reckless or negligent, whereas it's easy to show, obviously, the company through its people did it. So that will be a challenge for the prosecution, but I think it's been pressed upon it by the fact the company is going into liquidation.
Well, that sounds like a little bit of a legal nightmare, that one. All right, Bill, nice to catch up with you again this afternoon.
And you.
We appreciate you coming in. Now, if you have any legal questions, feel free to send them through to us, 2cc.net.au, by clicking on the feedback icon, or an SMS, 191918. We can answer them on the air every Wednesday, or if you like, we can organise something privately for you. Don't forget to start your message with 2cc if you're going to send us an SMS. That number again, 191918. In fact, before we go, stay there, Bill. I thought we'd just do something a little different today. Quirky laws. We thought we'd look up a couple of strange laws. Now, we've got a list that we've put together of the most ridiculous laws or urban myths. I'm not quite sure which ones are real and which ones are not, but I can tell you, in England, it apparently is illegal to die in the Houses of Parliament. I'm wondering whether that one's correct or not. In Ohio, it's against state law to get a fish drunk. Okay.
I mean, I'm not sure how you penalise somebody in the House of Parliament if they die. What's the punishment?
Well, exactly, yes. Right. In Miami, Florida, it's illegal to skateboard in a police station. Well, I'd probably believe that one. In Indonesia, the penalty for masturbation is decapitation. Wow. Certainly wouldn't want to be involved in any of that action. And in Florida, unmarried women who parachute on Sundays can be jailed. There you go. There's a few quirky laws. We'll work out which ones are correct.